Good night. This is U.S. Immigration Attorney Sharifa Tharp. I am here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments and I will answer your questions. So last night I talked about mistakes to avoid when you are applying for the marriage-based permanent residence. Now I'm going to talk about going from the 2-year to the 10-year. Mistakes to avoid there. The number one mistake that I see when you're going from the 2-year, I'm going to talk about different scenarios. First, I'm going to talk about when you're with your spouse. The number one mistake I see, and thanks so much for the love, I appreciate it, is not preparing for the next 2 years. So now you got your permanent residence, your 2-year permanent residence. So keep in mind, it's going to expire in 2 years and you're going to have to reapply. Now, when you're reapplying, it's very similar to the first application that you did. You have to submit evidence that your marriage is real, but you're not going to submit the old evidence from the beginning. This time, you're going to submit updated evidence to show that you continue to have a bona fide relationship. And guess what? If you try to submit old evidence, so for example, if you're going to submit evidence showing the correspondence you had, the text messages you had when you first started to get together, that's not going to cut it. They want to see that you continue to have a bona fide marriage, and that means that they want to see evidence now that over the next 2 years after you obtain the permanent residence. So I just want to backtrack a little because I jumped a little further than I wanted. I want to break it down a little more for you so you understand exactly what I'm talking about, especially if you don't have your permanent residence but you're about to get it and you want to know what will happen after you get it. So after you are approved for permanent residence, you could get in through a marriage-based process. There are 2 ways this could go. So the first is if you've been married to your spouse for over 2 years, you will get the 10-year. That's great because that means that it won't expire until 10 years. You could even apply for U.S. citizenship within those 10 years. You don't have to worry about losing your status, or it expiring. However, if you've been married for less than 2 years at the time that you're approved, you will get the 2-year conditional green card and or conditional permanent residence. That means that it's going to be essential for you to reapply on time. You have to submit a timely application within 90 days before it expires. So at the 1 year and 9-month mark, you have to start thinking about, or rather not thinking about, actually actively preparing your application for renewal. So that's number one mistake, is that you take it for granted and miss the deadline. Usually when you're jointly filing with your spouse, because you must jointly file with your spouse, by the way. This is not an application that you're going to submit on your own and then get it. Hi there, Bells Niari. Okay, I see you here. Great, thanks for joining in. So I am in the U.S. over 21. Mom filed I-130 when she was a permanent resident. Now she's a citizen. How do we upgrade? So Bells Niari, what you can do is you would have to submit a request to them or submit the change. So proof of your mom's citizenship in writing, and let them know that she's now a citizen. However, unfortunately, because now I would have to evaluate you personally to be able to give you personal legal advice. But generally, when someone is over 21 and they are here in the United States, I don't know if you're out of status, but if you're out of status here, and your U.S. citizen parent is applying for you, it doesn't matter in this case. It's a 6 to 7 year process. So it really isn't an upgrade, unfortunately. But to confirm this, to really make sure that no exception applies to you, call, schedule a consultation, and then we can talk more. How do I get SSN after getting the EAD? So BJ pumping, if you didn't check that you wanted, and there is a question on the I-765 that if when you're issued the EAD, do you also want an SSN? If you check that, you should be getting the SSN shortly after. So I say give it about 3 weeks for the social security number to come. It's taking about 3 weeks after you get the work permit. If you didn't check that box, then you should call your local social security office and schedule an appointment. Now, I don't know if I don't think they're doing in person, but when you call them, they'll be able to walk you through how you can go about getting your social security. So yes, so NIARI, make sure you schedule a consultation, because there's more to it than this. A U.S. citizen filing for a son or daughter who's over 21 is not going to be an upgrade, as in it's not going to shorten the time that you have to wait. But I want to see if there's an exception that would apply to you. Can you file for citizenship if you have a conditional green card, or you would have to get 10-year green card first? So great question, Pretty J, and it's nice to see you here. Thanks for your question. So here's what happened. When you are applying for the conditional permanent resident, when you apply at the 1 year and 9 month mark jointly with your spouse, at that point you're not going to qualify, because it hasn't been 3 years since you've been married to your U.S. citizen. But this process of going from the 2 year to the 10 year is taking long. And so say it takes another year, you haven't gotten a decision on your conditional green card application, changing it to a 10 year. At that point, you're 2 years and 9 months into your permanent residence. At that point, if you're still with your spouse, and all is well, you're living as a married couple together, you can file for citizenship at the same time. When you file for citizenship at the same time that you're filing for the conditional permanent residence, what they do is when they schedule the appointment, they're going to process the two of them at the same time. So it's going to be an interview that is, first the officer is going to review your conditional green card application. All being well, everything looks good. And remember that this interview is based on the bona fides, that they are satisfied that you continue to have a bona fide marriage with your U.S. citizen spouse or legal permanent resident spouse. But in this case, when we're talking about citizenship, it has to be a U.S. citizen. And so if they're satisfied, they will approve it on the spot and then move on to process your citizenship. So give you the citizenship test and then process your citizenship and tell you on the spot whether they've approved you. So you can, it's unlikely that you would be able to qualify. For example, if you've been married to you have had your green card for less than 3 years, you've been married to your, even if you've been married to your spouse for over 3 years, you still have to make sure that you have had the permanent residence for 3 years. 2 years and 9 months to actually apply, to initiate the application. So at that point, you're unlikely to be able to apply at the 1 year and 9 month mark when you're renewing your 2 year to a 10 year. But at the 2 year 9 month mark, if your application is still pending, you can go ahead and start applying for citizenship. So Bell's NIARI, so you are in status. So even if you're in status, it's not going to upgrade the time. You're still looking at a 6 to 7 year process. And one thing I want to note is when you're in status, it doesn't mean you're on the B2 or visitor's visa. because the visitor's visa is going to expire. You have to make sure that you maintain your status for the entire time that you're adjusting status in the United States. So Bells Niari, it's very important for you to schedule a consultation to fully understand what to expect. And remember, it's general information. The information I'm giving you here could change just based on more information that I learn about your case. And so that is where the consultation is going to be very important. You can schedule a consultation by going to the link in my bio. It'll take you to the website where you can call. There's a scheduling coordinator who's available up until 11 p.m. tonight. Or you can fill out a contact form or even do online chat right now. The scheduling coordinator is available to chat online. And I'm looking forward to speaking with you, Bells Niari. So you have to pay for citizenship different from the renewal. So yes, Pretty J, this is when you're applying for citizenship, you know, you're going to have to pay complete a separate application. You're going to have to pay additional fees because remember, getting citizenship through a U.S. citizen spouse isn't automatic. You have to apply for it and you have to qualify for it. And so that's going to require it's a different process, but the difference here is you're going to submit a different application, but they're going to, in the application, we note, so I usually submit a cover letter explaining that this is going to be a dual application process with the conditional and the citizenship. And when they schedule, they're going to schedule for both when they schedule the interview. So keep your questions coming while I'm here. I'm talking about the conditional permanent residence going from the 2-year to the 10-year. And I wanted to focus on the mistakes that can be made so that you can get tips out of it. You can avoid those mistakes. So the first that I mentioned was when you are married for less than 2 years, at the time that you obtain permanent residence, you're going to get the 2-year. And that's just a probationary, that 2-year process. A youthful 40, nice to see you. It's a kind of like a probationary period to make sure that your marriage is real, that you didn't just run off with a green card based on a fake marriage. So that's basically the purpose of the conditional permanent residence. And so at that point, when you do get your 2-year, it's not really time to relax. You still have to now look forward to the future and make sure you prepare to renew your 2-year to the 10-year. Now, the number one mistake is when you're filing with your spouse, right? Because remember, generally you are required to jointly file with your spouse. The both of you have to sign off on that application. And if you don't jointly file with your spouse, then that's a denial right there, especially if you're still with your spouse. But also if you don't jointly file in a timely manner within the 90 days before it expires, you could be in danger of having your status terminated and being referred to immigration court for removal. And so it's very important to apply within the 90 days before your card expires. If you miss that date, doesn't mean that it's all over for you. But what it does mean is now you have to show additional evidence to show extraordinary circumstances prevented you from applying on time. And that just makes things a little more complex and uncertain. So number one is be on time with your application when you're jointly filing with your spouse. That means 90 days before your card expires, you should be preparing and submitting that application. Now, the other mistake is now you think, okay, I got the green card. I'm just going to jointly file with my spouse. I'm not going to attach any updated evidence to show that I continue to have a bona fide marriage. That's a big mistake. That's a denial right there. Or a request for evidence. So what you need to do is make sure that you still prepare a very thorough application. Make sure that your application has updated evidence. So 2 years. So what have you done as a couple within the 2 years since you got your conditional permanent residence? Did you file your taxes jointly? Have you had updated bank statements? Did you open new bank accounts? Do you now share more benefits like health insurance or car insurance? Do you have a joint lease? Did you buy a house together? Do you have loans? Do you have credit cards together? That application is time to update your application with all that evidence, with all those updated evidence of what happened between the year after the year that you got your 2-year green card. That's going to be very important here. I mentioned yesterday that the process of applying for permanent residence through marriage is an exercise of storytelling. As an attorney advocating for my clients, I'm a storyteller to the officer. I tell the story of how the courtship played out to the very end, to let the officer see the full picture of the marriage, and for them to understand that this is a bona fide marriage. So now, with this updating the 2-year to the 10-year, what you're doing is you're continuing the story. So it's a continuation of the story. It's the next season of your marriage. And so that's how I look at it when I'm advocating for my clients. So what has happened in your marriage since then? And so make sure that your evidence is complete, thorough, and make sure that it's updated. It's not just old stale evidence that you've already submitted to them. Now, the other mistake is not necessarily related to the married couple, but sometimes the marriage breaks up before you actually get to apply. And a lot of people think, oh my gosh, if I can't jointly file with my spouse, I'm done. And they ignore the situation and they just live it out. They live it out until the card expires. They don't renew it because they don't think that they have any options to do that. That is also wrong. If you're in a situation where your marriage has been terminated, where you're through divorce, you're separated, you are facing mistreatment, your spouse has turned into a nightmare, maybe they were a nightmare before, you survived that, but you just can't survive another 2 years with them, then there are waivers that you could apply for to be able to apply on your own. So these waivers are basically, it's like a request to apply without that spouse. Now, there are you have to qualify in specific ways. So the first is you have to apply for a waiver based on divorce. So if you got divorced before your card expires, then you can actually submit your waiver request to renew from a 2-year to a 10-year before the 90 days that you're supposed to renew, or even after, because sometimes while you're jointly filing with your spouse, things fall apart. Then guess what? You can apply for a waiver. You don't have to give up. You don't have to wait for that fateful day that you get that notice to appear to go to immigration court for the deportation. You can apply on your own with this waiver request, but you must actively submit the waiver request. You must do it as soon as you realize that you're in a bad situation, that your spouse is not going to cooperate with you. You should submit this waiver request. It is essentially a way for you to get out of a bad situation and to continue to move on in your life with your 10-year. So, Pretty J, do you have to get the 2-year green card, or they give you 10-year green card if you're married less than 2 years? So that's the rule. So if you're married for less than 2 years, so if on the date the officer approves your permanent residence, and you have been married to your spouse for less than 2 years, you're gonna get the 2-year. If at the time you have been married for more than 2 years, then you're going to get the 10-year. So it's really about timing and when they finish completing your application. And while nobody wants their process dragged on for 2 years, sometimes that is actually, I guess, if there's any upside to long processing times right now, that could be an upside, is that by the time people are getting to their interviews, they have been waiting for more than 2 years. They've been married for more than 2 years, and they just get the 10-year. But nobody wants to be in that situation. You know, everybody wants their green card, whether it's a 2-year or the 10-year in a short period of time. But that's the rule right there. So there are 3 ways to that you can qualify for this waiver. So the one is if you can show that you are divorced by showing a divorce decree. If you haven't received you're welcome, Pretty J. If you haven't received so if you have not received your divorce decree yet, so if you're going through the divorce, still apply for the waiver, and what they'll do is they will issue you a request for evidence to send your final divorce decree when your divorce is finalized. And that usually, once they get that final divorce decree and they're convinced, because you still have to prove that your marriage was real. But now this time you have to show that your marriage was real, it just didn't work out, because that happens every day. People mean they had every intention of living together forever, and it just didn't work out, and they understand that. That's why they have this waiver based on divorce. The other is based on mistreatment, battery, or extreme cruelty. In this case, you must submit evidence to show that you experienced verbal, mental, maybe even physical, but physical isn't required here, abuse or mistreatment, or that you were treated so badly that it amounted to extreme cruelty. So that is the other one. You would have to apply for this waiver. You would have to show that that your marriage is bona fide. You had every intention to spend your life with them. Maybe you're still with them, but they are just being abusive, and that's why they're not applying with you, or that's why you're choosing not to make them apply with you. The third is extreme hardship. So to show that you will experience extreme hardship if you don't get the green card. So how long after doing your biometrics does it take to get your work permit? So biometrics are all over the place right now. So the best measure would be from the date that you applied. Right now, I'm seeing dates ranging from 7 months to 11 months. It has gotten longer. Getting the work permit has gotten longer, unfortunately. And that is frustrating. However, if you want a more accurate range of time that your work permit might take, you can go to uscis.gov. If you scroll down on the homepage, you'll see a link called Case Processing Times. Click on that and then find the service center that's processing your case. You can find the service center based on the 3 letters at the beginning of your work permit. So for example, you may see EAC. You can search for what service center that is, by Google, for example, or on the USCIS website, and then look up that service center and the form I-765, and it's going to tell you the range of time that specific service center is taking. All right, so I have been talking about mistakes to avoid during the process. So I talked about the importance of submitting to filing on time, to filing with complete evidence, to updating your evidence. So as soon as you get your 2 years, start to make a paper trail for you and your spouse. Make sure you save your bank statements. Make sure that you are continuing your transactions in your account. If it works best for you, that's gonna be based on the advice of your tax person. But if it is something that you can do or you can afford to do, file your taxes together. That's always a good indication that this is bona fide. Continue to see your friends and family, spend time with them, get updated affidavits from your friends and family to show updated evidence. So that's the other thing, show complete evidence, because if you show a lack of evidence or old evidence that you submitted already in the past, or if you show incomplete evidence, so like the front page of your bank statement or the front page of your tax return, that's not going to cut it. It has to be complete evidence. And then the other is, if you are filing, you can't continue to file with your spouse, don't give up, don't throw up your hands and think it's over for you. It's not. There are ways to apply on your own, and I listed those ways. You can apply based on divorce, you can apply based on mistreatment, or you can apply based on your extreme hardship. So those are 3 ways to get around the joint filing if you can't jointly file with your spouse. And then prepare for that interview. Sometimes they waive the interview. So for example, where the evidence is overwhelming that you and your spouse have continued to have a bona fide marriage. So for example, say you've had 2 more kids since you got married, since you got the 2-year green card, you've had 2 more kids together. That is definitely an overwhelming sign that you have a bona fide marriage, that you do have plans to spend your life together. In cases like that, they will probably just send the green card in the mail and you will be good to go. So that's great. But if they do have questions or they want to see it for themselves, they will schedule a final interview. And the final interview is going to be very similar to the marriage base. So be prepared, touch base with your spouse, make sure that you are in tune with them for that final interview. So that is all I have for you tonight regarding going from 2-year to 10-year, mistakes you should avoid, things you should do. I hope that you take this information, take this information as useful, but make sure you get legal advice, personal legal advice for your particular situation. Because this is not for you personally, but this is general information. So you don't want to take any action until you sit down with an attorney, such as myself, and get the personalized legal advice you want. If you want to schedule, go to the link in my bio. It's going to take you to the website. There's a phone number, there is a chat, and there is a contact form. Any one of those is going to lead to the scheduling coordinator, who will put you on my schedule, confirm your appointment, where we can get started. So I believe that's it. I don't see any more questions coming in. I will be back tomorrow, so I'll be back somewhere around 9:30. So look out for me, continue to follow me, continue to look out for updates throughout the day. Youthful 40, thank you so much. I appreciate it, and thanks for joining in and your support. Serenity's always informative. Thank you. I'm glad that you liked the topic, and I'm glad that you found it informative. Can I call you if I'm living in Jamaica? So what you can do is you can get in touch by contact form. If you don't have the ability to call our number, we do have the contact form there where you can do online chat. Let the scheduling coordinator know your number and we'll call you if you can't get in touch with us. So Alessandra, you can call if you have the means to, but we can also call you because we do have clients in Jamaica and all over the world, so we're not limited. We can have a consultation. Thanks so much for the love. Have a good night, everyone. I'll see you tomorrow, or I'll speak with you in a consultation.